Thank you, Mr. Chairman. Mr. Regan, thank you for being here. Appreciate it. The EPA recently offered a proposal, the Vulnerable Species Pilot, which I have some concerns with, and I think most people in ag and forestry and other pesticide users share that concern. The requirements of this proposal could be impossible to comply with, which would prevent producers from protecting crops and other property. In fact, 4 out of 5 producers claim they'll no longer be able to continue their farming operations if these regulations are enacted. So obviously it would jeopardize the livelihoods of rural communities. So my question is, can you explain to me why the EPA feels the need to put in place such severe restrictions without even first looking at the science to determine, is there a risk to endangered species? Furthermore, how does this approach reconcile with the EPA's responsibility under the Endangered Species Act and FIFRA to conduct effects determinations and risk assessments?
Well, I appreciate that question, and I think you and I both share a frustration here, which is we've had 30 to 35 years of a lack of compliance with the Endangered Species Act. And as I've discussed quite frequently with Secretary Vilsack, as we try to collectively tackle this issue, the courts have now taken the driver's seat in terms of setting the bars pretty high on EPA not responding to and losing litigation in court. And so what we've attempted to do is work very closely with USDA, resolve some of these litigation issues, and begin to expedite some of the reviews that would comply with the court's guidance, but also bring new products to the market. We do not want our farmers waking up and guessing every single day what's going to be on or off the shelf.
So you mentioned, I've heard you and tell 2 different members that you've coordinated with and have a good working relationship with USDA. So my question is, have you coordinated with Fish and Wildlife on this particular proposal? And if not, how does that reconcile with EPA's responsibility under the 2018 Farm Bill and the FY23 Consolidated Appropriations Acts, which required the coordination with Fish and Wildlife? I'm giving you credit for having coordinated with USDA because you've indicated that you have, but other federal co-regulators on proposed ESA pesticide mitigations?
We have. I think we've looked at this issue. I've looked at this issue through a very frustrated lens because I inherited a mess. But we have to solve it. And
so if I'm, and I don't mean to interrupt you, but my time is limited.
Sure.
So if I'm understanding you correctly, a lot of this is now in the wheelhouse of the courts. Is that correct?
A lot of it has been, and the courts have made rulings. And where you will see a slight difference sometimes with USDA or U.S. Fish and Wildlife is the court is telling EPA it has to meet that measure. And then we discuss, and quite frankly, maybe USDA or U.S. Fish and Wildlife have a higher appetite for risk. DOJ is serving as our attorney and may say, EPA, you can't afford to do X, Y, and Z. You're seeing a robust discussion across multiple agencies to try to get at some of these issues. And quite frankly, courts like the Ninth Circuit on chlorpyrifos and others have set a really high bar. That bar would not have been that high if we had been on the offense instead of the defense.
Right, and I do think we can agree that this is a very frustrating process, so I definitely think we agree on that front. Let me switch gears real quick. In 2020, the EPA's own scientific risk assessment demonstrated that the risks from lime manufacturing emissions are acceptable with an ample margin of safety and that no new regulations are necessary. Despite that finding, EPA is currently proposing to revise its national emission standard for hazardous air pollutants for the lime manufacturing sector due to a ruling in D.C. court case, Lean versus EPA. An economic analysis of the EPA proposal demonstrates that the rule would impose capital costs of almost $1 billion on an industry with only an annual revenue of about $2.3 billion. So given that rule would impose significant costs without an appreciable public health benefit, would you commit to adopting the maximum flexibilities under the Clean Air Act to minimize the burden of this rule on lime manufacturing?
I think what we want to do is ensure that we are meeting the letter of the law with as much flexibility as possible. I think we have to be reasonable, and I think what we want to do is protect public health and ensure that these industries can be productive because, of course, all of us rely on the food, fuel, and fiber that this industry produces.
Thank you. I appreciate you being here today, and I'll yield back the balance of my time.
Thank you.
Thank you, Mr. Crawford. I now recognize Ms. Salinas.